But the point is, I can get a long way into what should have been, I think, should have been fairly pristine land. And the development that has gone on has opened up all of Alberta. If you look at it from space, we're a pincushion. We're absolutely latticed with lines that cut into our public land and give access to humans to get into that space, which is going to affect the wildlife. The other significant observation, the other significant part of this bill is, for the first time, I really saw this administration tangle with rural property owners in a major way, and I can't say that the government came out of it unbruised. I think they actually got roughed up quite a bit. So, ultimately, what I am seeing as this debate progresses in how this Act has been adjusted continues to be a wrangle between the current administration and my colleagues to the ideological right, which are, essentially the conservative elites, let me call it that way, is the land use regional plans and sort of agreeing and setting out how land will be used in the future. So what I want to do is just go over a couple of the points of concern that I had. How are those notes? Just a second. There we go. Oh, there it is. That came to my attention that I think have not been addressed. So and I'm not going to go into the details because that's not appropriate in second reading, but I noticed that there is a requirement that regional plans or amendments be tabled in the legislature. My question is, will this be debatable as a concurrence motion? Are these just being tabled in the legislature for information purposes, or are they being tabled in the legislature for concurrence, for us to agree to that change of the land use plan? Because I think that's very important, particularly when we get back to my points later on about the Henry VIII clauses. So there's one question for the Minister to answer. And it specifically appears in the bill on page 3, amending section 5. And on page 7, amending section 12, which amends section 15, allows title holders to apply for the variance in respect of restrictions that have been put on. And the Minister was just talking about this at the end of his remarks. That and the section, sorry, let me just double check this. A section towards the end makes me think how much resource is going to be necessary, here it is, with the review, the request to review the regional plan. So, I have a lot of experience with municipal variances because I live in a neighbourhood that was completely, came under a redevelopment plan by the city and was 75% of the neighbourhood was redone. And a lot of changes, and I lived through this for 10 years. And honestly, on some days, I got 3 variance notifications in my mailbox in a day. So I'm very familiar with this. But in the city, there is a development appeal board. So those variances can end up in front of that. But I don't see what the administrative process here is around the variances. So someone applies for a variance, but what if somebody else doesn't want you to have it? Or is there notification for other people? Because a variance, if you've got a land use plan and someone applies for a variance on it, that's going to have consequences down the line. So who manages and foresees those consequences? And who is the decision maker about whether that variance is going to be granted and allowing anybody else to have their say on that? Or is this just cut off at a certain point? You can apply for your variance, nobody else has anything to say about it, and either they grant it or they don't. So that's the second question that I have. And Section 14, which is amending Section 19 of the Act, that was the one about the burden was put on the landowner to apply for compensation within a specific period of time. And by going back and forth, I was able to find, I was able to answer my own question there, which is, how did they get notification that this was going to happen? And there is another section that actually deals with the notification. So they don't just have to be constantly monitoring the Alberta Gazette, which I'm sure we all do every day. I mean, no, we don't, obviously. But there was an official notification section to landowners that something would happen with the regional plan or would happen with their property, so they would know and be able to deal with that. So I answered one of my own questions there. That's efficient. I also, yeah, I know. I'm also curious that there was no change to Section 20. And I'm pretty sure that Section 20 was one of the ones that was being talked about as a Henry VIII clause, in which the minister or the cabinet is able to change legislation without coming back to the House. And at the time, the government defended these clauses very strongly, and I argued against it, and I still am. Because, you know, as much as this place has been diminished, and it's a bit of an echo chamber today, so I suppose that's proving my point, you know, there's a lot of legislation now that can be dealt with by the minister away from this chamber, and we never know about it unless we're reading the Alberta Gazette. And I don't see that there was a change in Section 20 from the main bill, and I also question what was going on in Section 19. The minister is coaching me on the side that if I look at Section 21, that I will find out that everybody's treated the same. But I don't think that's quite answering my question. And when I look at under Section, sorry, I have to go backwards and find out where I started here. Section 14, which is changing Section 19 of the original bill. By the time you get down to the bottom of page 10 in the paper bill, it's talking about, again, 19.2 sub 19.1, 10. Lieutenant Governor and Council, which is Cabinet, may make regulations, that's regulations, respecting the form and manner of making applications to the Crown, the Compensation Board, or the Court of Queen's Bench under this section. I don't like it, but I understand what that's about. But then it talks about respecting the application or modification of Part 3, Division 3, and the regulations made under that division in respect of applications to the Compensation Board, Court of Queen's Bench under that section. Okay, here we go. Section 3, Part 3 of the main bill is that compensation section. Conservation directives. The whole thing is conservation directives, and Division 3, Part 3 is around conservation directives. So that says that this can be changed without coming back here, because it's empowering Cabinet to change that Part 3, Division 3, and I'm still questioning that. So I'd like to hear the Minister talk about that one.